So the self-ownage and desperation in this document, oh man, it is beyond repair, as that certain nameless party will do anything, and I mean anything, to shut down not only JD, but also anyone that had the audacity to go out and speak truth. Now, as you probably know by now, what that translated to was approaching not one judge, but two, and also Twitter, saying that over 200 accounts, they weren't individual entities. Oh no, they were all bots. They're all ran by one person out there, and you gotta unmask them, because of course that's not done for nefarious purposes. Now you can see the desperation and also the ill intent in that when they go in and they say, you know what, we don't need the information of over 200 users. Now that people are shooting that down, no, we need the information on two of them. Two unnamed accounts. Now, Twitter, for their part, hilariously calls out that certain nameless party saying, hey, you know what you're pulling here in LA? This stuff, it's already been decided on before in this same case in Virginia. What exactly do you think you're doing? Even though Circuit Court of Fairfax County, Virginia, denied the claim in January. So they point this out in the document. Oh man, self-ownage and ownage by Twitter. Oh, what a mess. You and I, we're going to talk about this document. We're going to talk about what it's predicated on. We're going to talk about who these two parties are that they're talking about here, even though they don't name them. We already know who they consider the quote-unquote worst offenders. And I want to add this too, and I'm going to say it very bluntly. If this person thinks they can legally and financially intimidate two people because they want to go out and utilize their free speech fundamentals, that's not going to happen. I'm a very good crowdfunder. I know many a good crowdfunder. And you know what? We'll make sure if they cannot afford an attorney, they will definitely have one that will crush this. And oh man, it will be fun to watch. So hey there to all you folks. Now, as far as this wonderful, blunderful document is concerned, I want to stress something that I said before about this getting called out because it's already been decided on. See, all of this is tied to the Virginia case, but that certain nameless party didn't like the decision that came in saying, you know what, this doesn't have any basis. So they've gone in, they've tried to file this in LA. They're trying to do a workaround. Imagine the judge, imagine the way that you would respond to this. Now, I'm going to show you the insanity of what's actually being requested in just a moment. And in order to talk about the accounts further, I'm going to show you everything that's built upon. But let's look at the new stuff first, and let's talk about what was discussed so we can talk about who this might impact. So, nature of the dispute and background. Defendant, the nameless person. I will call them the defendant or nameless person, whichever way it comes up. Issued a subpoena to non-party Twitter in connection with litigation against JD in the Circuit Court of Fairfax County, Virginia. Again, that's the upcoming May 17th, 2021 trial. The subpoena seeks, in relevant part, IP address information for over 200 Twitter accounts. Look at how crazy this sounds here, by the way, which defendant alleges are quote-unquote bot accounts. They're going to call them the accounts that supposedly publish smears and misleading statements about her that were maliciously operated by or at the direction of plaintiff. Now, there's the argument, by the way. They're either operated directly by JD or they're at the direction of JD, pretty much saying they're at the direction of Adam Waldman. He's the one pulling all the strings. He's the puppeteer. Now, you'll notice a date here, January 28th, 2021. Leading up to that date, you had Twitter actually answer subpoenas for those 200 accounts in a really well-reasoned way. They said there are multiple reasons we can't turn this over to you. Therefore, the judge, though, comes back and says, hey, why don't you folks work that out? And they boil down their multiple reasons to one. Hey, judge, if you say that this isn't a free speech violation, then we can turn that stuff over. You have back and forth ensue, and well, this is where we land. During a January 28, 2021 informal discovery conference, defendant's counsel stated that he would narrow the subpoena to seek IP address information only for the 2 Twitter accounts that the council claimed were the quote-unquote worst offenders. Now that's interesting, isn't it? How could you have worse offenders if you have one person going out pulling all of the strings? This basically tells me that there are individual differences between the accounts. Therefore, there must be individuals at the helm. I mean, that would make sense, right? Otherwise, you would have all of these accounts pretty much performing unilateral. But hey, Twitter and reasoning. The court agreed, by the way. This is the worst thing that I heard about that. The court agreed. Now, what's funny there is the only way that they could get the court to agree is to whittle down hundreds of people, because this whole idea is beyond absurd. It's beyond laughable. And still, they add a caveat to that. But required defendant to submit evidence of defamatory statements posted on Twitter by those 2 accounts. The court also disagreed with defendant's representation that the subpoena does not seek identifying information because IP addresses can be used to unmask anonymous speakers. So they're saying they're telling you, number one, hey, you need to prove what you're saying, and we disagree with you. You're saying that you're not going to use this in a negative way. You're just going to find out whether that's JD or his associates. Oh no, what you're trying to do here, you're trying to bully and intimidate. You're trying to unmask anonymous speakers. That thing there, that should tick people off, and it should tick people off to the nth degree. See, if you look at that subpoena, it's not just asking for your IP address. I mean, that's bad enough. It's asking for any and all IP addresses from which the account has ever logged in, aka you went to your relative's house for Christmas. You utilized Twitter. Well, they want to know where your relatives are. They want to know if you've ever logged in at work. Basically, it doesn't just unmask everything about you. It unmasks other people around you, too. And this, it's not just a violation. It's a violation, and then some. So you go beyond that as well. They want to know account details. If you've ever been suspended, how many messages have been suspended? For each message that was deleted, what was the reason for that? And they want to know if you've ever been rate limited. Basically, they want to be able to go in. They want to be able to defame you if they can't call you a bot. Yes, very much. They want to put that bullseye on anyone that has had the audacity to speak up. This is terrible violation of any free speech fundamental, and it should not be allowed to stand. Now, from Twitter's perspective, all of this is laughable. And you know what? From a court perspective, it probably is too. After all, we have seen Virginia sound off on this before. But hey, we're going to have yet another attempt to go out and unmask. And this is what they have to say here. Defendant's supplemental status report, it does not appear to identify sufficient evidence of defamation. It doesn't show any evidence of defamation, in fact. And from Twitter's perspective, if defendant intends to pursue the subpoena further, she must obtain a court order confirming that her request satisfies the First Amendment. That's going to be a very slippery slope, by the way. You're going to have to go in. You're going to have to find things that you can prove are defamation. That doesn't mean it went out and hurt your feelings. It has to meet certain narrow confines, and good luck with that. I mean, that's going to be very difficult. After all, if you look at governing law, to unmask an anonymous speaker online, the First Amendment of the U.S. Constitution and the California Constitution require a litigant to establish a prima facie cause of action and to attempt to notify the speaker. That hasn't happened at all. Either one of those. Moreover, the California constitutional right to privacy requires a showing that there is compelling need for the discovery that outweighs the privacy rights of the speaker. Hey, that's going to be interesting to try to prove to. I mean, what exactly grounds was that built on? So the argument here, what they try to produce, this shows you this is all about getting your fee-fees twisted. It's unclear to a Twitter whether defendant's new evidence establishes a prima facie cause of action. Several of the quoted statements appear to be neutral statements or opinion. They include language such as, "I'm so proud of Depp fans," or refer to defendant, a movie star, a public figure, that's what you're talking about, as a quote-unquote nobody. Even tweets that appear ambiguous may be statements of opinion, given the nature of the underlying litigation, the fact that allegations in the litigation are newsworthy and hotly debated by fans of the parties, as plaintiffs and defendants counsel attest to at the previous IDC, and the parties' celebrity status. Almost all of the identified statements are retweets, so they're trying to nail you on retweets, dissemination of other accounts' tweets, and the act of retweeting could be expressing an opinion about the retweeted statement. Additionally, some or all of the statements could be true. Accordingly, Twitter is concerned the defendant's evidence is anonymous speech that is protected opinion about two public figures. Given these issues, Twitter's position is that a court must undertake the applicable balancing test before Twitter can produce the requested data. As noted in Twitter's previous statement and discussed at length in the January 28th IDC, the IP address information defendants seek could be used to unmask anonymous speakers. It would too, by the way. Defendants' representations to the contrary are misleading and ignore the court's conclusion on January 28 that the requests for IP address do seek identifying information. Like I said, when a court looks at that stuff, they indeed disagree with it. Additional issues with the defendant's supplemental statement. Twitter is also concerned about two additional aspects of defendant's supplemental statement. First, the statement still appears to raise arguments related to defendant's harassment claims, even though the Circuit Court, Fairfax County, Virginia, denied that harassment claim back in January, as the two-party discussed back in January 28th IDC. These accounts republish the content of other users at rates and consistencies that belie authentic human control. Whether or not the accounts are bots relates to defendants' claims of coordinated harassment. It has no bearing on the defamation claim that defendants cited as justification for continuing to pursue the subpoena. Given the parties' discussion on January 28th IDC that the subpoena is moot as to defendant's harassment claim, it is unclear to Twitter why defendant has raised the issue again in her supplemental statement. Second, defendant's statement appears to ignore counsel's January 28 narrowing of the subpoena to the two quote-unquote worst offenders. The statement cites tweets from several different accounts, not just two, and discusses characteristics of quote-unquote many accounts. These representations and arguments overlook defendant's counsel commitment to narrowing the subpoena during the January 28th IDC. Now, in the proposed solutions, by the way, you can see how vindictive and how desperate this is. Again, trying to put people in their place. How do you know that? Well, you see something in the last statement here. Let's read through this and really pay attention. Twitter respectfully proposes that if defendant intends to pursue the subpoena further, she must, number one, limit her request to two accounts consistent with counsel's agreement to do so January 28th IDC, and two, seek a determination from the court regarding whether the two accounts may be unmasked in light of the fact that only her defamation claim, not a harassment claim, remains. In addition, Twitter seeks confirmation that the Adam Waldman subpoena has been withdrawn. So they withdrew the thing going after Adam Waldman, but still they want to go after two people out there because they want to unmask them and basically, they want to name, shame, and harass them. That says a lot, doesn't it? Now, all of this is predicated on the idea that JD was so upset that he needed to destroy somebody, and to accomplish this task, he individually and through his representatives and agents in Virginia created, coordinated, controlled, and or manipulated social media accounts created specifically for the purpose of targeting that nameless person, computer-controlled social media accounts, and or groups of unauthentic accounts controlled by a single agent to amplify content misleadingly. AKA, you're a bot? What kind of bot are you, by the way? Well, there are a number of newly created foreign language accounts, specifically or predominantly designed to damage that nameless person. Many of these accounts have what kind of signatures? Reflecting, where's that origin again? Oh yeah, Russia. You're a Russian bot. Mr. Waldman, of course, he could put that together because he's publicly associated with Russian individuals with the capability to organize this kind of stuff. Can you imagine saying that about someone, taking that to the court, asking for information? Well, that's what this person did because, again, they want to name, they want to shame, they want to shut people down. Now, along with that, it names several accounts, but it fixates on two. You can see them here. Two accounts are responsible for approximately 50% of the targeted attacks on that nameless person. Then they go into my Grindelwald. Then they say, they use their platform to amplify anti-nameless person hashtags and false information being disseminated on that nameless person. It also amplified the Change.org petitions described above, repeating calls for that nameless person to lose contracts and business expectancies. And as evidence of its origin, saying, this will give us the reason that we can go in and unmask it, it routinely tweets statements of JD's attorney and agent, Mr. Waldman, on a near daily basis, often praising the otherwise unknown attorney, even going as far as to say, "I love you, Waldman. I love you, Waldman, indeed." What a monster. What a monster, indeed. But anyway, that breaks down everything. It lets you know the two parties, too. And I'm very serious about what I said. If somebody thinks they're going to legally and financially go in and bully somebody, think again. Myself, Yellow Flash, we've talked about this before. And you know what? You folks, you don't stand alone. If somebody wants to step to you for something as absurd as that, we're going to have some real fun times. But anyway, let me know what you think about that. As always, and I mean this, I appreciate the heck out of you for showing up and listening. Make sure you share this. You know how to feed the algorithm, all of that by now too. And if you want to help out the channel, check out all of the links, especially our comic book. Comic book closes down the day after Valentine's Day. We're going to print. We have all of our perks in right now. I've been posting pictures and on. Very exciting time. If you want to help us out there, it definitely lets us go out, step to an industry that is just like this mess that doesn't want to listen, for different reasons, but still. And yeah, regardless, if you're just here to listen, appreciate the heck out of you. And yes, we will see you soon.